for both counts. I am going to release you on your own recognizance. You'll be ordered to commit no acts of domestic violence, not have any contact with the victim, or go to the victim's residence or place of work. You have a hearing coming up on November 4th, 2024 at 10 a.m. That'll be in Tucson City Court. Oh, I'm sorry. Because you're in custody on another matter, you'll be, I gave you the wrong date. It'll be October 4th, 2024 at 1:45 p.m. That'll be a video review hearing. And I'm not appointing a counsel for you at this time because I'm releasing you on your own recognizance. It does have, that box is already checked. Should I uncheck that? Okay. All right. Since you already have counsel appointed in your other cases, I'll appoint counsel in this matter. That's a contract attorney, Redmond. Do you have any questions, sir?
No, sir.
All right, we're adjourned. Thank you.
Your Honor, this is Court Interpreter Pedro Davis, and looking at the list, I don't see any parties identified as Spanish speakers for this evening's initial appearances.
That's correct. You can be excused. Thank you.
Thank you very much. Good night.
Good night.
Your Honor, whenever we get to felonies, I am present with the public defender.
Thank you very much. We only have one other city court matter.
I think I'm like that. I didn't do this.
Sir, could you please state your full name?
Daniel Joaquin Arguelles Jr.
All right, sir. And sir, you have one count, which is aggravated assault. You do have the right to remain silent. Anything you say can be used against you. Do you understand that, right?
Yes, I understand that, right?
Okay. All right, and in this case, the state is asking for a $15,000 bond with supervision by pretrial services. Any response from defense counsel?
Your Honor, is this a misdemeanor?
No, it's the felony aggravated assault. Mr.
I
Arguelles,
apologize. I thought we had one more. I apologize. Who?
Daniel Arguelles.
Okay. Your Honor, I do see that he's in custody on other charges. He is being held no bond and he has a prison sentence to complete. So he's not being released. I'd ask the court to set the bond at $7,500.
$7,500. Okay. Any response from the state?
Nothing additional, Judge.
Okay, so since he's in custody on another matter, he doesn't need to be supervised by pretrial services. I don't need to include that, do I?
No, Your Honor.
Okay. All right, hang on just a moment. All right, Mr. Arguelles, I'm setting bond at $7,500. You're not to have any contact with the alleged victim. I am appointing the public defender's office to represent you. Your next hearing is a preliminary hearing that's set for August 8th, 2024 at 1:30 p.m. You'll be in custody already for that, so you'll be transported or they'll do it by video. That would be the preliminary hearing. Anything else from either side?
No, Judge.
All right, thank you. We're adjourned.
Sure, we're good.
Sir, could you please state your full name?
Victor Rios Nabor.
All right. Sir, you were picked up on a warrant. It's criminal trespass in the second degree. It's a class 2 misdemeanor. You do have the right to remain silent. Anything you say can be used against you. And were you aware that you had a warrant out for your arrest, sir?
I was.
Okay. Why didn't you show up for your hearing? Sir?
When I got out of jail.
Yeah.
When I got out of jail.
Were you aware you had this warrant?
Well, yeah, I was willing to.
Okay. All right. Well, if I release you, will you promise to appear at the next hearing?
Yes, Your Honor, I do.
Okay. All right, I'm going to release you on your own recognizance. You're not to have any contact with the alleged victim. You're not to go to the incident location. Your next hearing is October 28th, 2024 at 8:30 a.m. That's at Pima County Justice Court. That's your arraignment. And I'm not appointing counsel at this time since you're not being held. But you'll be released as soon as they can process you out. Do you have any questions, sir?
No, Your Honor.
All right, we're adjourned. Thank you.
Thank you very much.
Ma'am, could you please state your full name?
Shay and Lyles.
Okay, thank you. All right, ma'am, you have two cases. The charges are on the first one, endangerment, domestic violence, possession of drug paraphernalia, failure to use a seatbelt, possession of drug paraphernalia again, and then possession of drug paraphernalia. The second case, you have false reporting to law enforcement, possession of drug paraphernalia, criminal trespass in the third degree, and then again, possession of drug paraphernalia. You do have the right to remain silent. Anything you say can be used against you. And ma'am, are you working? Do you have a job or anything like that?
Yeah, currently, I do, like landscaping yard work for the neighbors that live in my neighborhood. It's actually going pretty well, just the heat, sucks, so,
Okay. If I release you on your own recognizance, do you promise to appear for the next hearing?
yes, Your Honor.
Okay. Were you gonna say something? Okay. Hang on just a moment.
One of these days, I'm gonna come for you. I'm gonna come.
So these, I'm sorry, Stephanie, these are both warrants, right? So I should do it. Okay. So I will. All right. Right. Ma'am, I'm gonna enter a not guilty plea on your behalf on the new counts. And since I'm not holding you, I'm not appointing counsel at this time. Your next hearing for both matters is November 4th, 2024 at 2 p.m. You do need to be present. If you're not present at that hearing, a warrant could issue for your arrest. Do you understand?
Yes, Your Honor.
Do you have any questions?
I do not. Thank you.
You were adjourned. Thank you.
All of you, come up the stairs. Over. I'm gonna take a seat.
Sir, could you please state your full name?
Alan Colberry.
All right. And sir, you had two charges against you, felony criminal damage and felony endangerment. You do have the right to remain silent. Anything you say can be used against you. And then counsel, two issues with the probable cause. One is that for the endangerment charge, there was no victim listed that I can see. And then on the felony criminal damage charge, there was no dollar amount attached to the damage. From anything from the state on either of those issues?
Judge, as to the endangerment, the way the statute is written, it does not require a specific victim. It could literally just be everybody on the roadway while he's driving. Given that he crashed into another vehicle, we would ask that you find the probable cause as to the endangerment. As to the criminal damage, it does not indicate, as you indicated, it does not indicate an amount. It just indicates that it was totally disabled. Given the way the statute is written in that it requires an actual monetary amount. That one, Judge, I have nothing additional to say as to that one, but we would ask that you find probable cause onto the endangerment.
Okay, from defense?
Your Honor, I do agree with the state's assessment of the statute in terms of endangerment, but I do agree that there is a issue. Obviously, criminal damage can be anywhere from a serious felony to a misdemeanor based on amount. We don't have an estimated amount, so I would ask the court to dismiss that count today.
Okay. All right, I'm gonna find PC on the endangerment charge. I'll dismiss the felony criminal damage without prejudice. Let me just write that in. Hang on. All right, I've handwritten those changes on the interim complaint. Then the state is asking for release to pretrial services. And defense counsel, do you want to be heard on that?
No.
Okay. And you're in agreement with that?
Yes.
Okay. All right, so Mr. Comery will be released to pretrial services. He's not to drive without a valid license. He's not to possess or consume alcohol or illegal drugs. And I am appointing the public defender to represent him. The next hearing is the preliminary hearing that's set for October 18th, 2024 at 1:30 p.m. Sir, you do need to be at that next hearing. If you're not present, a warrant could issue for your arrest. Do you understand?
Yes, sir.
All right, thank you. Anything else from either side?
No, Your Honor.
All right, thank you. We're adjourned.
Thank you.
Martinez?
Sir, could you please state your full name?
Joseph Alexander Martinez.
All right, sir, you have one count against you. That's aggravated assault. You do have the right to remain silent. Anything you say can be used against you. And the state is asking for a $25,000 bond and then supervision by pretrial services if the bond is posted. Defense counsel, any response to that?
Yes, Your Honor, it appears that he has no criminal history, so he's a 1 on the NCA and the FTO scale. He's a lifelong resident of Tucson and has ties to the community. Pretrial services was able to verify that there is secured housing for him with a friend. I'd ask that the court set the bond at $6,000.
Is that a bond amount that he could post?
I do not believe so.
Any response from the state?
Judge, given the nature of the offense where he went up to it seems like a random security guard and strangled her twice, and other witnesses had to physically remove him, Judge, we're asking for the higher bond.
Okay, thank you. All right, I'm going to set bond at $25,000. If bond is posted, he'll be supervised by pretrial services. He's not to have any contact with the alleged victim or return to the incident location. I am appointing the public defender to represent him. His next hearing is the preliminary hearing, October 8th, 2024 at 1:30 p.m. Mr. Martinez, if you do happen to be released, you need to be at that hearing. If you're not present, a warrant could issue for your arrest. Do you understand, sir?
Yes, sir.
Anything else from either side?
No.
No, Judge.
All right, thank you. We're adjourned on that matter.
Thank you.
Martinez, just have sit out there. Boss.
Yeah.
Out there with your ass.
Sir, could you please state your full name?
Sergio Foss.
All right, sir, you've got 2 cases against you. The first one is aggravated assault, domestic violence, and disorderly conduct, domestic violence. Then the second one is aggravated assault, domestic violence, and criminal trespass, domestic violence. Under the law, you do have the right to remain silent. Anything you say can be used against you. I understand there may be a victim on the line. Is that correct?
Yes, yes, Your Honor.
All right. Okay, when we get to release conditions, ma'am, I'll ask for your input. And
Okay.
On both of these cases, the recommendation, hang on. So the recommendation for both was a bond of $40,000. Is that for the both of them, or in other words, concurrent or consecutive?
Judge, I had combined them into one recommendation, and I think we just copy and pasted it into a second. So I would just ask that they be concurrent, and it'd be $40,000 or $20,000 for each case consecutive.
Okay. All right, and defense counsel?
Your Honor, he's lived in Tucson for 23 years and has ties to the community. He is currently connected with behavioral health in the community through Kodak. I'd ask that the court set the bond at $15,000.
All right, thank you. And to the victim, ma'am, is there anything you'd like to say about release?
Just the same thing that I told for child services, I'm opposed to his release right now. I do not, just because of the nature and the severity of what he did last night, I do not want him back at my house right now. I feel like he needs to be in there and he needs to get the help that he needs. It's, we just went through this in May, and I thought at that point he had learned his lesson. He has a substance abuse issue that there's nothing I can do for him out here anymore. And if he gets out, it's going to be bad for everybody.
Okay. All right, thank you, ma'am. All right, I am going to set bond at $40,000 on each case. Those are run concurrently. I'll put that in the order. The other release condition, if bond is posted, he'll be supervised by pretrial services. He's not to commit acts of domestic violence. He's not to possess firearms or weapons. He's not to have contact with the alleged victim or go to the victim's residence or place of work. I'm appointing a public defender to represent him in both matters. And both matters will have the next hearing for both will be the preliminary hearing, October 8th, 2024 at 1:30 p.m. And Mr. Paz, if you do happen to be released before then, you do need to be present at that next hearing. If you're not present, a warrant could issue for your arrest. Do you understand, sir?
Yeah.
Okay. Anything else from either party?
No.
No.
All right.
No, Judge.
Thank you very much. We're adjourned.
May I be excused?
Us. If I let you out, you're gonna be cool.
And Judge, I think the victim's asking to be excused on that last case.
Yes, of course.
Okay. Thank you, Your Honor. Have a good night.
You too.
Thank you.
Sir, could you please state your full name?
Aaron Dean Paulie.
Thank you. And Mr. Paulie, you have 2 counts against you. I'm sorry, 3 counts. Possession of dangerous drugs, possession of narcotic drugs, and possession of drug paraphernalia. You do have the right to remain silent. Anything you say can be used against you. And counsel, did you get the, we did an interim complaint with some handwritten amendments. Did you both get that?
We did from the state judge.
Your Honor, I'm not sure if I got that. It is my understanding that the state intends to dismiss.
Oh.
No.
And Judge, I did an amended recommendation, and I submitted it just before we started court after I got the amended interim complaint. And my recommendation now is just release to pretrial services and asking for a smart court hearing.
Okay. All right. So initially the interim complaint didn't have any indication of what the substances were and no specifics regarding the glass pipe, which would have been the paraphernalia. And then the handwritten changes were that the black substance was NIC tested and showed positive for heroin with a weight of 1.872 grams with packing, and then the white substance was tested and that tested positive for meth, and that weight was 7.477 grams with packing. The pink substance was not tested due to precaution. So it does seem that with that amendment, there's probable cause for both charges. Defense counsel, do you have any objection to release to pretrial services with a smart court hearing?
No, Your Honor, I had noticed that issue in the original interim that it did not state which drugs were used, but it sounds like the amended interim is sufficient. So no objection to pretrial services release.
And we've got the preliminary hearing would be set for October 18th at 1:30. Did you want to set it further out and waive time, or you want to leave it like it is?
He will waive time.
Okay, so can we get, can I get another date? 30 days out? Is that good?
Yes.
Okay. Hang on, we'll get another date here. And Mr. Paulie he does want to participate in smart court?
Yes.
Yes.
Okay, great. Josefina, what would it just be the November 18th, or would it be a different? November 12th, okay, at 1:30? Okay, all right, let me make that change. All right, Mr. Paulie, you've got two hearings coming up. You've got your smart court hearing, which is October 7th, 2024 at 9 a.m. Then you've got your preliminary hearing, which is November 12th, 2024 at 1:30 p.m. You need to be present for both of those hearings. If you're not present, a warrant could issue for your arrest. And then you're going to be released to pretrial services. And you're ordered not to possess or consume alcohol or illegal drugs. I am appointing the public defender to represent you. I think that's everything. Anything else from either side?
No.
No, Your Honor.
All right, thank you. We're adjourned on that matter.
Smith?
Sir, could you please state your full name?
Anzo Smith.
All right. And sir, you have 2 counts: discharging a firearm within city limits and criminal damage. You do have the right to remain silent. Anything you say can be used against you. The state is recommending a bond of $20,000 and pretrial services supervision if the bond is posted. So any response?
Yes, Your Honor. He has no criminal history, so he's a 1 on the NCA and the FPA scale. We don't have a reason to believe that he wouldn't show up for his court dates out of custody. He's also a lifelong resident of Tucson with ties to the community. I would also note that the allegation is that a firearm was discharged and not that someone was injured. Additionally, people are allowed to discharge firearms in self-defense, and we don't have enough information yet to know whether something like that could be at play. So based on his lack of criminal history and all of the other reasons, I'd ask the court to consider release to pretrial services. If the court is inclined to post a bond or impose a bond, I'd ask that it be $2,500.
Is that an amount that he could post?
He said probably not, although if it's a secured amount, that could change things.
Okay. Any response from the state?
Judge, given the nature of the offense where he did discharge a firearm in city limits, and per the interim complaint, it does note that he struck 4 parked vehicles. Thankfully, nobody was in those vehicles. It could have been a lot worse, so that's the reason we're asking for the bond we are.
Okay. All right, thank you. All right, I am gonna set bond at $20,000. If bond is posted, he'll be supervised by pretrial services. He's not to possess firearms or weapons, and he's to surrender any firearms that he does have. He's not to have contact with the alleged victim. He's not to go to the incident location. I'm appointing the public defender to represent him. His next hearing will be the preliminary. That's one.
This, yeah. Oh, hurt.
The next hearing is October 8th, 2024 at 1:30 PM. Mr. Smith, if you do happen to be released before that, then you do need to be present at that hearing. If you're not present, a warrant could issue for your arrest. Do you understand?
Yes, sir.
Anything else from either party?
No.
No, Judge.
All right, thank you. We're adjourned. And counsel, that's the last of the cases I have.